First schedule deals with entries, and this deals with D, because you're not to apply now the provisions of the Constitution of India, and they are all incorporated in the Constitution of India as applicable to Jammu and Kashmir. So 356 also comes there, Part 3 comes there, Preamble comes there, Directive Principles of Policy come there, but that's all with concurrence. Therefore, it didn't come at this stage, that happened later. So it's not just a question of application, it's a question of substantive understanding of what 370 is. Even if you want to apply a provision without modification, you need consultation with respect to or concurrence. There is no third way of doing it. 246 shall apply subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply. So you can't pass a law.
So what is the effect of clause 2 and 3 of article 246 not applying in relation to the state? Because
the residuary power is with the state.
No, but 246(2) refers to the power of Parliament and the state to enact laws on the concurrent list.
That's fine.
No, but if 2 is not applicable, then neither the state nor the Parliament can enact a law on the concurrent list.
It will be because of 1B, Malaz. It only tells you the methodology, Malaz, that's all. The point is, what my Lord is putting to me is, the President can exercise powers under 370, dehors a modification. That's an exercise of plenary power. That's what my Lord is putting to me. But this clearly shows that even that exercise has to be done with concurrence. If it relates to the concurrent list and consultation if it relates to instrument of accession, can't be done any other way. So it's not a matter of practice alone. It's the substantive interpretation of 370. Kindly see the first column, Malaz. All the articles apply. Part 9, Part 11, Part 12, Part 15, Part 16, Part 17, Part 19, Part 20, everything applies. But in those parts, there are exceptions and there are modifications. That's set out in the third column. Nobody disputes that. The whole part applies.
Clause 3 of the order seems to suggest that the only provisions of the Indian Constitution which would apply to the state of Jammu and Kashmir are those which are specified in the second schedule, and that too with the modifications which were made.
Absolutely. That's our submission. And then this is superseded by the 1954 order. For example, Part 3 at this stage was not to apply now. It's not in the second schedule.
Let's go to this now the
54 order.
54 order.
Yeah, that's one. So, Malad, supposing the entire constitution was to be made applicable, Malad, it will require concurrence, no? Only some are applicable, some are not yet applicable. You will see that 356 comes later. 356 doesn't come at this stage. That would also require concurrence, and concurrence was taken. So, any provision of the Constitution of India which relates to the concurrent list would be made applicable subject to the concurrence of the state government. Consultation and concurrence, instrument of accession and concurrent list. And Article 1 and 3 are out of it.
So the exception made here is the entire constitution is adopted subject to the modification made there. Unlike
other than 1 and 3. Other than 1 and 3.
1 and 3 is already there.
That's right.
Unlike 1950 order, which had specific articles were made applicable, now the entire constitution.
No, because 356 was not applicable at this.
No, but there would be a clause in this saying 356.
It's part by part, not true, Malas. Part by, see part 1, part 2, part 3. It's part by part. It's not all.
Is 356 specifically excluded?
No, at this stage. Excluded.
It would be excluded
after
at this
part 5. You have part 9.
Yes, come to page 15. 356 is excluded.
Yes,
so the entire constitution was made applicable by the 1954 order, except to the extent of exclusion.
Well, this part 5 is state 11 straight away. There's no question of the entire constitution being included.
Just 1 minute.
Mr. Sibal, my learned brother, maybe if with respect, right? I'll tell you another reason. I'll give you another, just apropos what fell from Brother Sanjeev Khanna. Just see now part 3. First, we'll just see one small provision, clause 2. Clause 2 of the order of 1954.
Correct.
Yes.
It says the provisions of the Constitution, which in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications shall be as follows. Now, one thing is very interesting. The word only, which we found in the 1950 order, has been deleted in the 1954 order.
Right.
So only goes.
Yes.
Now let's go to part 3 for a moment, and just to test the hypothesis.
We'll just go to part. Yes.
Now just see clause C in part 3.
Clause. Yes,
right?
I got it, Madam.
It says in clause 3 of Article 16, the reference to the state shall be construed as not including a reference to the state of Jammu and Kashmir.
Correct.
Now, if we see Article 16(3) of the Constitution,
Yes.
it says nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local authority within a state or any requirement as to residence within that state or union territory prior to such employment or appointment.
Right.
Now, if the entirety of clause 16 were not to apply to Jammu and Kashmir,
Yes.
what was the reason for saying that only clause 16(3) will apply subject to these modifications?
For the simple reason that Muller's other clauses in respect of clause 3 of the Constitution came into the J&K Constitution later. And I'll show that to your Lordship.
But is it your contention, therefore, that
entirety of 16
that
applies.
16(1) didn't apply to the Jammu and Kashmir?
It did apply. It applied.
The part which is mentioned.
But how did it apply then?
No, part 3 applies in full. When it says part, your Lordship may see they have a serial number and then they have A, B, C below each of these parts. So when they mention the part applies in full. Now, in that part, A, B, C will tell you the exception or modification of the provisions of the Constitution in that part. So when the part is indicated, the part applies in full. In the 1950 order, it was column. So in the second.
That's what I was saying. See, in the earlier, the manner of printing of the two notifications
Yes,
is slightly
Yes, that's all. That's all.
very good.
In the first one,
has been
there is a
expressly
column,
excluded.
it is an article.
Yes.
Then what is the exception sort of
Correct,
carved
correct.
out?
And the modification. Now it's
Modification exception carved out.
So now
In
it's.
this, the way it is printed as I see it,
Yes.
when they say part 3, it means part 3 applies, but
these exceptions and
one
modifications.
column of modifications which were there
Yes.
are specified underneath it.
That's exactly
That's
what it is.
exactly.
Nothing, no difference.
Other than what has been exclusively excluded.
Yes.
The rest of the part 3 applies.
That's correct. That's all that there is. That's all.
This is simple.
Like
I
16,
think
1 and 2 apply.
this is simple. Just come to page number, internal page number, the first page, page 10 of the
Page
notification.
10, okay.
The provisions of the Constitution.
Yes.
This means the entire provisions of the Constitution.
Page 10, your Lordship's PDF page 10?
Yes,
Yes.
that's a notification, 14th May 1954. 2, clause 2. The
Page
provisions.
13, not 10.
13 of the
Or page 13.
Yes,
Yes,
13.
yes, page
Yeah.
13. You're right. The provisions of the Constitution,
Yes.
which in addition to Article 1 and 317, Article 317,
Yes.
because that's covered by 3.
Yes, yes.
Now, the provisions of the Constitution refers to the entire provisions of the Constitution.
Correct, correct. Yes.
Shall apply in relation to the state of Jammu and Kashmir. Full stop.
Yes. Which,
Second-
the word
second-
also left the word out, which.
Yes, I'm aware of that. That second part says the exceptions and modifications subject to which they shall also apply shall be as follows.
Correct, correct.
So thereafter, the exceptions are carved out
Yes.
with regard to each part of the provision of the Constitution, which are either not to be applicable or applicable with modification.
Correct, correct.
And if you go down, it specifically says 356 is excluded.
Yes.
In case this was specific inclusion, they need not have specified 356 is excluded, because by implication 356, if not mentioned in the schedule, would have been excluded.
But with the greatest respect, when you say, kindly read it, just see, kindly see part 18.
The very fact that some articles have been
Kindly see
excluded,
page 18, kindly see page 18. PDF page 18.
yes,
352, the following new clause shall be added. Above that,
correct,
part 818.
correct.
And therefore there are exceptions.
We are then at item.
But the part applies, but there are exceptions and modifications.
So
that-
like part 18 applies, for example, part 18 applies,
Yes.
the modification is specified below that.
Yeah.
Then small clause B, 13, part 3, small
But
b.
therefore, there is no dispute on
The
that.
entire Constitution has been applied.
356,
They were
357,
except what
Exactly.
So these three these three articles are part.
Kindly see, and also it says the provisions which shall apply shall be as follows. Which shall apply? They are enumerating the provisions, that's all, Madam.
The next after that is what are the modifications?
Yes,
Or what is omitted. So
that's right.
mostly they are modifications, but some are omissions.
Yeah.
For example, in part 19, if you see,
Yes, I have it.
Article 362 and 365 are omitted.
Omitted, yes.
366 clause 21 will be omitted.
Omitted, correct.
Otherwise, the whole of part
Will apply.
other than this will apply.
That's right.
The approach is instead of going provision by provision and enumerating 395, they went part by part. And they said this whole part applies subject to.
But
But
ultimately,
what about those parts which are not specified as parts?
They don't apply.
No, that is a problem. I'm not sure you're right on that.
You may not be right on that.
We have, in fact, in volume 1, we have the Constitution of India as applicable to Jammu and Kashmir, which shows that this is how it was.
Part 4 won't apply.
No, not at this stage. Not at this stage. Part 3 did not apply till 1954. Preamble did not apply till 1954. That's exactly the way they proceeded.
well, that's the only.
And this is significant. Yes. So part 4A is omitted at that stage. 4A came later anyway, but part 4.
The one way to look at it is part 4 will absolutely apply, of course, but without any modification. But
That, with respect,
where there is
that's not the
modification, then we
understanding-
specify.
That's not the understanding of the government of India then. That's not the understanding of the state of Jammu and Kashmir then. That's not the understanding, Malad, of any authority then. Malad, now we are saying, no, that was all wrong. Actually, everything
We're not
applies.
saying, we're just
And they don't,
discussing.
and you don't need consent.
Mr. Sibal, as I see it, as I said,
Yes.
every order
Yes,
extended different parts of the constitution
that's right.
to Jammu and Kashmir. Now, if a particular provision is with modification, it says so. Now, it may be by provision wise,
Yes.
or it may be part wise,
Yes,
it may be by any method.
correct.
But it keeps on extending by the
Yes,
orders
yes.
which are passed.
Yes.
So first one was provision wise in a sense. This one is part wise because practically the whole part was to apply
Yes,
with certain modifications.
that's correct.
To the extent that it is not to be applied, it is excluded.
That's right. That's the only submission. That's the only, and in any case, Malad, 1 and 3 are, 1 and the 370 are excluded.
That is from because of the first notification, separate clause C was made.
That's correct.
Clause C was made for Article 1.
So, Malad, this argument then doesn't take us anywhere because we are dealing with 370. We are not dealing with any other part of the Constitution. So we can, Malad, interpret the orders any which way you want, but it cannot touch 1 and 370.
The two major points to my mind are this. One is your submission that Article 370 has acquired a permanent feature of the Constitution.
Yeah.
That's the debatable issue.
Yes.
Which both sides will debate. Next is suppose it is not permanent. Then what is the manner of abrogating articles?
That's right.
Is that procedure followed or not?
That's correct.
The only two issues as I
Correct,
see it
correct.
in the whole
But I'll
issue.
hope and try and convince you that it is permanent. I will try and convince you. I know, Malad, your lordship says it's debatable and it is debatable. There's no doubt about
So
it.
both things are debatable means both sides will argue this point
Yes,
out.
it's really debatable. But I tell your lordship, Malad, why it is permanent. Malad, now, for the moment, Malad, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether
course.
the procedure has been followed or not followed. They will say we followed the manner of abrogation.
Absolutely.
You will say not.
Now, Malad, so far I've only referred to provisions of this Constitution. But, Malad, your lordships will have to look at the Constitution of Jammu and Kashmir because that Constitution, Malad, was framed and cleared in 1957. So, Malad, Malad, Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your lordship, it can't do anything more than that. Right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent.